Okay. So we're going forward on a pretrial for trial case set next week for live jury trial. The parties have been instructed to deal with their motions in limines or confer on their motion in limines and try to pre-admit as many exhibits as we can. So let's go ahead and go forward on this. Is there any objections to the plaintiff's motion in limine in this case?
Yes, Judge, I have about nine items, and a couple of them just need clarification. But beginning with the first, number three, item number 3 on plaintiff's motion in limine, any comment by defendant's attorneys that informs the jury of the effect of its answers to the questions in the charge. I just, that seems vague to me. I don't know what that means or what's trying to be limited.
No one ever, I mean, yeah, I grant that every time. I'm sure every judge does. You can't tell them, I've never seen anyone do this, but like, if you award $50,000, that would be in excess of the policy limits of my client, and therefore you shouldn't award that. I mean, that would be like, that's not something they're deciding. So you couldn't bring that up, but I mean, I've never seen anyone violate that.
Judge, in my third jury trial ever as a baby defense lawyer, plaintiff's counsel in Vordaer stood up, and the first thing he said is, "There's going to be a jury charge that acts as to find the defendant negligent. If you answer no to that question, I lose."
So that would be in violation.
That was in violation. That's the intent of that.
Yeah, that it's standard. We see them in every case, so I wouldn't worry about it.
Okay. All right. Understood, Judge. Number 10, I don't know how the court rules on letters of protection, so
I keep them out.
Okay. Number, let's see. Number 15 and a couple of the other ones are related, but I don't know how the court rules on, whether or not if the provider refers the plaintiff to a attorney, and attorney referrals to providers, that type of thing.
I keep those out too, generally.
In this case, I think we only have attorney referral, not provider referrals, and so that really, I think that's attorney-client privilege, and I agree it's a little trickier when the provider refers to the attorney, but I don't think that's the case here.
Okay. So 15, granted, Judge, is my understanding, correct? Okay. 16, I don't agree to that, just because that puts it on me or it doesn't allow me to point out witnesses that they may have been able to call but didn't call. I don't think that just because a witness is available to me that I have to offer evidence in favor of my client. I don't have a burden in this case.
Say that again.
So with regard to number 16, where it says their failure to call a witness to testify
Tony, we are on the record. Sorry.
That's okay. So comment regarding plaintiff's failure to call a witness to testify that was equally available to both parties. Your Honor, my argument is that if they don't bring a witness, I don't think that it necessarily matters that I didn't call them. I don't have a burden. So pointing out that they didn't meet their burden by not calling a witness, I don't think should be limited out.
Okay, response.
Well, it's been a long time, Your Honor, since I've read Sanders versus St. Paul Fire, but I think that's exactly what that case held, which is the fact that a witness is equally available. There's a lack of relevance by trial strategy not to call them if they're equally available, and trying to profit from that in argument by saying, well, plaintiff didn't call the doctor to testify. Plaintiff didn't call the chiropractor to testify. I just have these records. That's the point of the business record affidavit. And I think it's unfairly prejudicial.
I do think that's the law, Mr. Jones. If you want to brief this further, you can, but I've dealt with this hundreds of times, and that's how I've always done it. So, but if you want to try to brief it and maybe change the law or point out new law, that's fine, but I'll grant it for now. Did you submit an order, Mr. Shelton on the motion in limine, I can't find it.
Well, if we haven't, Your Honor, I'll get one over. right
Actually,
if we're done.
never mind. I just found it. I apologize.
Okay.
It wasn't where I thought it would be. Okay, give me 1 second. Will, can you grab the order for me? Okay. All right. Anything else?
Yes, Judge. Number 23, I think, is at this point, it's covered by the case that came out in Re Allstate concerning the reasonableness and necessity of charges and counter affidavits. I think previously what most courts were doing was disallowing any mention of reasonableness and necessity if there had not been a counter affidavit or if one had been stricken.
I
But
think you're right. I think you're right on that. In Re Allstate does change that, unless Mr. Shelton, you have a different reading of In Re Allstate.
Well, I guess I'm.
Mr. Shelton, are you there?
Yeah, I'm here. I'm trying to look at practically what Mr. Jones is saying with regards to 23 is going to happen in our trial. We have affidavits, counter affidavits haven't been filed in this case that I know of.
I think understand that.
I've
In
never.
Re Allstate is not. I don't agree it was correctly decided at all, but I have to follow the law just like you do, and so I think that if you look at In Re Allstate, it clearly says for whatever reason that they're able to argue reasonableness and necessity even without a valid counter affidavit. So
Okay.
But
okay.
that's my read of it. If you want to, it's not how I ever did this, but I do think that's the law, and I don't want to,
Yeah, okay. I mean, I've never held that just uncontroverted affidavits are proof that the charges are reasonable and necessary. They just are available to support a judgment. So if Mr. Jones is going to argue without evidence that they're not reasonable and necessary somehow, I guess I agree with you that In Re Allstate improperly decided allows him to do that.
Yeah. But again, you're welcome to argue In Re Allstate and say there's something different here, maybe, or distinguish it. That's my read of In Re Allstate. But again, for now, I'm going to deny. What number was that?
23, Judge.
So I'm going to deny 23 or overrule 23. All right. Anything else?
I'm sorry, Judge.
Anything else?
Yeah, 24. I'm not sure, but I think that would preclude me from even asking a question. Well, did you go to your family care, primary care physician? Did you follow up with your primary care physician? Did you go to an ER doctor on the day of the accident? Things of that nature. I think those are valid questions as to why the plaintiff didn't go see those providers that are actual medical doctors as opposed to a chiropractor or other non-medical doctor.
And I don't think there's any relevance to that. And that also tends to trade into the suggestion of attorney referred medical treatment.
I'll sustain it for now. If you want to try to argue it later, you can.
Okay. Number 29, I think, is the last one that I had an issue with. I just wanted clarification. It's just in regards to what a potential juror, how they know any of the witnesses. I think during voir dire, what my practice has been is to ask the question, do you know this party, this party, this party, this party? And if there's anybody that raises their hand, we can take that up outside the presence of the jury to delve into what the relationship is and whether or not it is proper for that juror particularly to be on this case. But I just needed clarification on that one, because that's as much as I would be wanting to get into in front of the entire panel is, do they know this person, period?
Well, and that's why we have that second sentence that we just request that if someone raises their hand that they know me, know my law firm, know the parties, any further questioning happens outside the jury panel.
So let me talk about what I think comes up, what I think you're most concerned about, I imagine, is generally, Mr. Shelton, you work with MAS, right?
Correct.
And they advertise a good bit.
There's some advertising, but yeah, I mean, we're concerned about someone that knows our firm that had a bad experience saying, wow, those guys are the worst, and polluting the whole panel.
Yeah, so I would say this, generally what I do in that case is don't allow you to go into the issue of what the law firms are. I don't think Mr. Jones should be allowed to say you work for MAS, and by the same token, he should. You can't say, does he work for, I don't know, you with Allstate or State Farm?
That's correct, Judge Allstate.
Now, if you open the door and say, hey, I work for MAS, then that's kind of your issue. You know what I mean?
Mm-hmm.
So, but generally I do, like, let's say somebody, you go to church with Mr. If Russell Jones goes to church with, you know, Sally Smith on the panel, I usually do go into that right there just to find out what the details are. And it may spark other people figuring out they know Mr. Jones because they also go to that same church or something. So I generally allow that. I have had situations where attorneys against my recommendation, and you know this has happened with Long Car's office, where they just bring up, hey, I work for Long Car, and you know, it's like, well, they probably wouldn't have figured that out except for you brought it up. So, so I will say, Mr. Jones, assuming that Mr. Shelton agrees to this, or if you bring up the fact that he works for MAS, I may mistry the case and not be very nice to you at that point, because this isn't about what law firm either of you work for, or what insurance company you work for, Mr. Jones. So you can't have it both ways.
I understand that, Judge. And again, I would just reiterate, all I would be asking is, and I wouldn't mention the law firm. I think I want to say that that's another one of the motions in limine that I have not brought up and is therefore agreed to, is not mentioning that MAS. But so on this particular item, I was just wanting to clarify that if we got
the reason I bring this up, Mr. Jones, is there is another attorney that I don't think he works at your office that is notorious for doing this.
Okay.
And so but usually the other side doesn't fight it. And I'm like, I've granted a motion to limine, you're not fighting this. He brings up if somebody works for Long Car, Abbott, or whatever, and it always causes issues. And I don't want that to be an issue in this case because it's not relevant.
Right. And that's not something that I do. I don't think I've tried a case before the court, but that's not.
No, and I'm not criticizing you because you've never done that. I want to make it 100% clear. You've never done it, but other attorneys, Allstate, another particular Allstate attorney that is very well known, he does that regularly. So anyway, so what number was that?
That was number 29, Judge.
So 29 is sustained in part. So just no law firm mentioned.
Right. And that goes into 35, Judge. They specifically, the plaintiff's law firm.
And that
was. And Mr. Jones, I'll just let you know the reason we have that is we had a case tried in Tyler, Texas, and not that you would do this, but the defense lawyer just continually drew out in a South Texas drawl, Majurad, Abu Saad, and Syed, to terrify the people of Smith County that the law firm was 3 people with those last names. So that's why that one's there.
I believe Mr. Syed told me just briefly about that. So yeah, I am aware. So I understand.
Yeah, Mr. Jones, I don't think you would do that, but if you did that in my court, that would not go over well.
Understood. That's all I have, Judge, with regard to the plaintiff's motion to limine.
All right. Any objection to the defendant's motion to limine?
Yes, Your Honor, but I think you've covered some of it already. Number 4E, that's their collateral source. The E provision has an exception that would allow them to ask about letters of protection or unpaid healthcare charges or reduced healthcare charges, and I think you've already covered that one.
I've already
So
covered that.
next would be 15, hearsay medical opinions. So it's my client can't say on the stand his spine is like a jelly donut, and there's
case law on that. If Mr. Jones, if you think he crosses the line, that, I mean, we all are familiar with this case law. If he crosses the line and says, like, tries to provide medical diagnosis, like, I have a herniated disc at the C4, C5 level, and it causes blah, 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 and tries to provide medical testimony, then I agree that would not come in. But if he says, hey, my doctor said I had a herniated disc and I would have these issues, there's kind of a line there. And so you just need to object if he crosses the line.
Will do, Judge.
I don't see that very often, but it does happen. All right, so 15 is denied. Anything else?
Yes. The last one would be 40, the Allstate reptile theory limine that's in all their motions in limine. And I just think it's too broad as it's worded. Any argument, reference, or insinuation that the jury should act as the conscience of the community, protect the community from risk, consider community safety, cast the defendant as a danger to society, or punish the defendant to discourage similar conduct.
That's too broad. It's denied. You can object. It's denied. Okay, that's the motions in limine. Can we
Yes,
pre-admit exhibits? Are you ready for that?
Give me just 1 second.
Have you guys conferred on this?
Not on the exhibits, Judge. I'm agreed to the redactions as long as they redact any reference to insurance and or the HIV status of the plaintiff. I shouldn't have said that, but yeah, as long as we do those redactions, I don't think I have many objections. But no, we have not conferred on the actual exhibits.
But I don't have any objections to the defendant's list as provided. But I mean, I think this was filed back in 2018 or 2019. I don't have any problem with defendant's exhibit list.
All right. So what exhibits are we pre-admitting? Plaintiffs, what are you offering? Plaintiffs 1 through what?
Give me just a second, Your Honor.
And based on the exhibit list that's been filed, Judge, it was filed October 11th of 2021 by the prior attorney. Based on this list, the only objection I would have, not concerning those redactions we previously discussed, is number 18, which is the estimate for the plaintiff's vehicle. And just the reason for that is that's an estimate prepared by someone that is not testifying. So it'd be a hearsay expert opinion that we haven't been placed on notice of any expert.
So you agree to 1 through 17 with redactions?
Yes, that's correct, Judge.
But it's 1 through 17 with redactions are admitted. We'll wait on 18. Is that all the exhibits?
Yes,
that's all the ones listed in the list in the plaintiff's exhibit list.
What numbers exhibits are defendants offering?
I do not have any exhibits to offer at this time, Judge. There may be 1 or 2 if there's a impeachment issue, but with regard to a case in chief or anything like that, I don't have any that I plan to offer.
Okay. All right. Any other pretrial issues we need to work with before the trial on Wednesday?
No, Your Honor, but I do want a point of clarification. If for some reason there isn't a jury Wednesday, are we just reset, or are we still looking to Thursday?
If we can get one Wednesday or Thursday, we're going forward.
Okay.
Judge Moore I'm going to turn this off.